Hello, my name is Molly Stump. I'm the Palo Alto City Attorney, and I'm going to be talking to you today about the Brown Act. Welcome to service as a Board or Commissioner in Palo Alto. I hope that you really enjoy your work here. We're going to talk today about how to do that consistent with the legal rules that govern service on a board or commission. What we're going to do today in this training is briefly give you some historical background about the development of these Brown Act rules and the reason for that. We're going to go over some basics about what is a meeting, what is an agenda, what needs to be on an agenda, and what it's for. We're going to talk about public comment, and we'll talk a little bit about some special issues that come up with respect to applying the Brown Act for boards and commissioners. This is a primer today. It will introduce you to the topic. It won't answer absolutely every question that may come up during your service in Palo Alto. So if you have a question as you're doing your work, please don't hesitate to be in touch with your board and commission liaison and ask your question to that person. They can help you comply with the rules, and if they don't know the answer, they can be in touch with the clerk's office or with the city attorney's office and get you the answers that you need so that you can do your work consistent with the law. First, let's talk a little bit about why we have the Brown Act. In 1952, a journalist in San Francisco named Michael Harris, who worked for the San Francisco Chronicle, did some investigative reporting on practices that were common for a lot of local boards and agencies around the state. And he ran a series in the Chronicle describing private meetings. And these were fairly common at that time. Board or commission members, city councils, special districts, they were meeting behind closed doors and doing the public's business, making important decisions, and the public didn't have an opportunity to know that this was going on or to participate in the process. What Mr. Harris found is that these board and commission and council members were saying they wanted to protect their agency from public controversy, and they were looking for efficient debate and a way that they could discuss issues that may be sensitive and come to decisions. This is inappropriate under the law at the time, but the California legislature decided the following year in 1953 that the rules needed to be clearer. So Assemblymember Ralph M. Brown carried the Brown Act and it was adopted in 1953. It's been amended many times since then, and it governs now and is very familiar to all local boards and commissions, and basically requires that all meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting except as otherwise provided in this chapter. So unless there's a specific exception in the Brown Act itself, the presumption is that boards and commissions do their work in the open and the public may listen, watch, and participate. Who does the Brown Act apply to? It applies to the elected body of a local agency. So for Palo Alto, that's the city council. It also applies to all appointed multi-member bodies, whether they have decision-making authority or are advisory. The Brown Act applies, therefore, to your board and commission. The key concept in the Brown Act is the concept of a quorum or a majority. So that means that for a 7-member body, a quorum is 4. For a 5-member body, a quorum is 3. Now, the Brown Act also can apply to a standing committee if you and your board or commission have one of those. A standing committee is a regular committee of less than a majority that has continuing jurisdiction and a regular time and place to meet. The Brown Act doesn't apply to ad hoc committees. An ad hoc committee is a group of less than a majority of a body that's tasked with a limited set of duties and doesn't have a regular time and place to meet and is intended to go out of business at some point. Those types of bodies are not required to follow all of the rules for the Brown Act, although some boards or commissions decide to follow the rules anyway, and that's of course fine to do. Be aware that the Brown Act applies to you from the time that you are appointed to the board, even if your service hasn't formally begun. What is a meeting? A meeting under the Brown Act is a majority of members coming together at the same time or place to hear, discuss, or deliberate on any matter within their subject matter jurisdiction. Usually this happens, in the city council chambers or somewhere in City Hall or maybe at Coverly or Lucy Stern, but you should be aware that a meeting can occur in other ways as well, and we'll talk about that in a minute. Meetings also include workshops or retreats that you might have. They don't include a number of things that are specifically listed in the Brown Act. So those are contact between individual or small group, less than a majority, members of the board or commission with city staff or with constituents. Those are not meetings. Also, the Brown Act has a list of things that are exceptions to the meeting rule, even if there's a majority of your board or commission in the same place and time. And those are conferences that are announced and open to the public, community meetings on issues of public concern that are free and open to the public, meetings of other legislative bodies, such as perhaps your counterpart board or commission in another city. And social or ceremonial events are also not meetings. Now, for all of those things, it's still important that the board or commission doesn't get together in a majority to discuss city business that's within your jurisdiction. That would not be appropriate. We need to talk for a minute about serial meetings. Serial meetings are prohibited by the Brown Act. These are meetings that occur even though the majority of the body is not together in the same time and place. What does that mean? If your body has 5 people and one commissioner speaks with a colleague about an issue, that's not a meeting under the Brown Act, and it's not prohibited. You may talk amongst yourselves less than a majority. But if the commissioner then reaches out to another member of the body and talks about that same issue, a meeting has occurred even though those conversations did not occur in the same time and place, and that's called a serial meeting. That can happen if one commissioner has a series of conversations in turn, or one commissioner has a conversation with a second commissioner who then goes to a third commissioner and a fourth commissioner. That's also a way that a serial meeting can arise. And then the third way that a serial meeting can arise is if a third party who's not on the board or commission carries messages between board or commission members. So for example, if you're meeting with a member of the public about an issue, that's perfectly legitimate. It's not an issue under the Brown Act. But suddenly the person says, "Oh, Commissioner, I've spoken with 2 of your colleagues and they think that," okay, so you need to stop them when they start that sentence and say, "Okay, hold those thoughts. Please don't tell me what other board and commission members think about this topic. We need to discuss that at an open noticed meeting. You and I should just talk about what you think and what I think." One common way that serial meetings can arise in the modern world is through email. Email or telephone, very, very easy for serial meetings to arise inadvertently, and so it's something to be very cautious of. One-way communication by email from your board or commission liaison is not a problem under the Brown Act, but if a board member accidentally hits reply all and responds to the whole group, then you can have a serial meeting inadvertently through that process, so it's something to be careful of. Blogs and chat rooms can also be problems. Even though there are other members of the public present, those don't meet all of the Brown Act requirements for a meeting because there's no agenda and all of the public is not aware that the discussion will occur. And if you're participating in those, you may not be aware that other board or commission members are also present, observing, listening, or responding, perhaps even without identifying themselves. All right, so you know what a meeting is now. So let's talk for a minute about agendas. When you come to your first meeting, you will see that there is an agenda. And the reason for that is the Brown Act requires the public to be informed in a brief and general way of the topics that will be discussed. That way, the public can decide if they care about the issue and they want to be present, to listen in real time to the discussion, and maybe to even participate in it through public comment. Agendas have to be established at least 72 hours in advance for regular meetings. A special meeting that's not at your regular time and place requires an agenda 24 hours in advance. So the staff liaison will help to put this together for you. And what you need to be aware of is that the way that the agenda item is described is going to govern what you can discuss. You have to stick to things that are on the agenda. And if you want to talk about something that's not on the agenda, it needs to be placed on a future agenda, and you can talk about it then. The Brown Act doesn't apply to members of the public, and members of the public have an opportunity in every meeting to raise any issue they want under what's called general public comment. They're not violating the Brown Act if they raise an issue that's not on your agenda. Board or commission members, however, can't get into an extended discussion about a new topic that comes up that way. It is okay to ask a short question, to make a brief comment, or to direct the staff to respond or place an item on a future agenda, but an extended discussion would not be appropriate and should be reserved for a future time when there's a formal agendized item. It's also okay in your regular meeting to have a place where board or commission members can make general announcements. They should be brief. It's not an opportunity for an extended discussion, but it's all right to have an announcement section on your agenda. There also can be brief questions or comments to staff, and if your procedures allow it, there can be a place to suggest new business or future items that should be put on an agenda. But again, not an extended discussion because the public hasn't been made aware that the topic might be debated. Let's talk for a minute about public comment. There's two types of public comments at every meeting. One is there needs to be a place on the agenda for members of the public to come and raise any issue that's within your jurisdiction that's not on the agenda. Then the second type of public comment is on every specific agendized item, the public has to be given an opportunity to speak. The chair and the traditions and customs of your board and commission can decide when the public comment occurs on agendized items. It's okay to do it right up front, or maybe after a brief staff report, or after the board or commission has discussed the item. It just has to happen before there's a vote on the item. The public has very broad scope about what to talk about in their public comment time. They cannot disrupt the meeting, but other than that, they have broad leeway to make comments that may be even disagreeable or not consistent with the values of the community generally. Those things should be allowed. It's okay to ask the public to identify themselves, but you can't require that. If someone wants to speak without giving their name or their address, they have a right to do that, and they should be allowed to participate in public comment. It's also okay to put reasonable time limits on public comment. And, reasonable might be 3 minutes or 5 minutes. It even could be less than that, perhaps 2 minutes, depending on how crowded your agenda is and how many members of the public are there to speak. It is important that any time limits that are placed on a speaker are applied consistently to all speakers. All right, so what happens if there is a violation of these procedures? The thing to do, first of all, if you're concerned that there may have been some problem under the Brown Act, is to let someone know. Be in touch with your board or commission liaison and raise the issue with them. They may be able to explain to you that there is not a problem, or if there is a problem, they will figure out how to address it. And the first obligation of a public agency is to cure and correct the problem. And typically what that involves is more process. It may be that an item that hasn't been properly agendized isn't going to be discussed. It'll be placed on a subsequent agenda. Or if an item has already been discussed and there was some kind of problem, it may be raised again correctly in an open and public meeting and addressed. Sometimes if the body has taken an action, the right thing to do is to rescind the action, to have your process in public, complying with all the rules, and then to consider and take a vote again. There are sections of the Brown Act that allow a member of the public who believes the act has been violated to eventually go to court and to have a judge consider whether additional procedures should be required. Sometimes the public agency may even have to pay for the member of the public's attorney time if there was indeed a significant problem with complying with the Brown Act. And there is even a provision in the Brown Act that talks about criminal prosecution. That would only be invoked in a very unusual circumstance and if there was a very substantial noncompliance and it was intentional. But the provision is there, and we should be aware of it because it underlines how significant these obligations are and how important it is that we do our work in an open and public way so that the public can participate fully in the process. Thank you so much for listening. We've come to the end of our primer on the Brown Act. If you have any questions about what you've heard today or questions come up during your service, please be in touch with your board or commission liaison. They can help you get answers to your questions, and they can also direct you to the clerk's office or the city attorney's office if necessary so that we can make sure that we're complying with these procedures as we do the important work of representing the people of Palo Alto. Thank you again.